April 12, 2023. Real estate law vocabulary. 1. Administrative agency. An administrative agency is a government entity created by statute or regulation that is tasked with implementing and enforcing specific laws or regulations within a particular area of jurisdiction. Administrative agencies are responsible for making and enforcing the rules, regulations, and policies, conducting investigations, issuing licenses or permits, and overseeing compliance with the law in their respective areas of authority. Examples of administrative agencies in the context of real estate include the California Department of Real Estate, which regulates and licenses real estate professionals in California, and the Consumer Financial Protection Bureau, which enforces federal consumer protection laws related to financial products and services. 2. Administrative Procedure Act. The Administrative Procedure Act, APA, is a federal law that governs the procedures and practices of administrative agencies in the United States. The APA establishes the requirements for rulemaking, adjudication, and judicial review of agency actions, and provides procedural safeguards for individuals and entities affected by administrative agency decisions. The APA aims to ensure transparency, accountability, and due process in the actions and decisions of administrative agencies, including those related to real estate matters. 3. Arbitration. Arbitration is a method of alternative dispute resolution in which parties to a dispute agree to submit their dispute to an impartial third party, known as an arbitrator, who makes a binding decision on the matter. Arbitration is often used as an alternative to traditional litigation in court, and can be a quicker and less formal process for resolving disputes. In the context of real estate, arbitration may be used to resolve disputes related to contracts, leases, property transactions, or other real estate matters. 4. California Department of Real Estate. The California Department of Real Estate, DRE, is a state agency in California that regulates and licenses real estate professionals, including real estate agents, brokers, and appraisers. The DRE sets licensing requirements, conducts examinations, issues licenses, and enforces real estate laws and regulations in California. The DRE also oversees the recovery of damages from the Real Estate Education, Research and Recovery Fund, which provides compensation to consumers who suffer financial losses due to the wrongful acts or omissions of real estate licensees. 5. Civil law. Civil law is a branch of law that deals with private disputes between individuals or entities, such as contracts, property, torts, and family law matters. Civil law sets forth the rights and obligations of parties in relationships and provides mechanisms for resolving disputes through civil litigation in court. Civil law is distinct from criminal law, which deals with offenses against society and is prosecuted by the government. 6. Common law. Common law is a body of law that derives from judicial decisions, rather than statutes or regulations. It is a legal system that is based on precedent, where principles and rules are developed and applied by courts over time. Common law is often referred to as judge-made law, as it is created and refined through the interpretation and application of legal principles by courts in specific cases. Common law is the foundation of the legal systems in many English-speaking countries, including the United States, and provides a framework for interpreting and applying statutory and regulatory law. 7. Compensatory damages. Compensatory damages are monetary damages awarded to a party to compensate them for losses or injuries suffered as a result of another party's wrongful act or omission. Compensatory damages aim to restore the injured party to the position they would have been in had the wrongful act or omission not occurred, and are intended to compensate for actual damages, such as financial losses, property damage, or personal injuries. Compensatory damages are different from punitive damages, which are intended to punish the wrongdoer for their conduct, and are typically awarded in civil lawsuits as a remedy for harm caused by a wrongful act or breach of duty. 1. Constitutional law. Constitutional law refers to the body of law that is based on the federal and state constitutions and establishes the structure, powers, and limitations of government. Constitutional law defines the fundamental rights and freedoms of individuals, outlines the responsibilities and authorities of government branches and officials, and provides the framework for the operation of the legal system. In the context of real estate, constitutional law may come into play in cases involving property rights, land use regulations, takings, and other matters that implicate constitutional principles, such as due process and equal protection. 2. Declaratory relief action. Declaratory relief action is a type of legal action that seeks a court's declaration or determination of the rights, duties, or legal status of parties in a dispute. A declaratory relief action is initiated by a party seeking clarity or resolution on a legal issue, and is often used to obtain a judicial determination of the party's rights and obligations before a potential dispute or controversy arises. In the context of real estate, a declaratory relief action may be used to resolve disputes related to property rights, easements, boundary disputes, or other legal issues that impact real estate interests. 3. Due process. Due process is a fundamental legal principle that guarantees individuals the right to notice and an opportunity to be heard before being deprived of life, liberty, or property. Due process requires that government actions be fair, impartial, and in compliance with established legal procedures and protections. In the context of real estate, due process may come into play in cases involving property rights, land use regulations, eminent domain, or other matters where individuals or entities may be subject to government actions that impact their property interests. 4. Exemplary damages. Exemplary damages, also known as punitive damages, are a type of damages that may be awarded in addition to compensatory damages in a civil lawsuit. Unlike compensatory damages, which are intended to compensate the injured party for actual losses or injuries suffered, exemplary damages are intended to punish the wrongdoer for their wrongful conduct and deter similar conduct in the future. Exemplary damages are typically awarded in cases where the wrongful conduct was particularly egregious, malicious, or willful, and are meant to serve as a deterrent and discourage similar conduct in the future. 5. Foreclosure. Foreclosure is a legal process by which a lender takes possession of a property used as collateral for a loan, typically a mortgage, when the borrower fails to repay the loan as agreed. Foreclosure may be initiated by the lender through a court action or through a non-judicial process, depending on the laws of the jurisdiction and the terms of the loan agreement. Once the foreclosure process is completed, the lender may sell the property to recover the outstanding loan balance or take ownership of the property. 6. Injunction. An injunction is a court order that prohibits a party from engaging in a particular action or requires a party to take a certain action. In the context of real estate, an injunction may be sought to prevent a party from engaging in activities that are perceived as causing harm or violating rights related to property, such as construction activities that encroach on a neighbor's property, or a violation of a land use regulation. Injunctions can be temporary, preliminary or temporary restraining order, or permanent, and may be granted when the court determines that the party seeking the injunction is likely to suffer irreparable harm if the requested relief is not granted. 7. Liquidated damages. Liquidated damages are predetermined or agreed upon damages that are specified in a contract as the amount of compensation to be paid by one party to another in the event of a breach of contract. Liquidated damages are typically used as a means of estimating the potential harm or loss that may result from a breach of contract, and provide a predetermined amount of compensation without the need for further proof of actual damages. Liquidated damages clauses are commonly used in real estate contracts, such as purchase agreements, lease agreements, and construction contracts, to allocate risk and provide for a remedy in case of breach. 1. Jurisdiction. Jurisdiction refers to the authority of a court or administrative agency to hear and decide a particular case or matter. It determines the geographic area, subject matter, and type of cases that a court or agency has the power to adjudicate. Jurisdiction may be based on various factors, such as the location of the property, the nature of the legal issue, or the parties involved. In the context of real estate, jurisdiction may come into play in cases involving property disputes, contract disputes, zoning or land use issues, and other legal matters that fall within the jurisdiction of a particular court or agency. 2. Mediation. Mediation is a form of alternative dispute resolution, ADR, in which a neutral third party, known as a mediator, assists parties in resolving their disputes through negotiations and discussions. The mediator helps the parties identify their issues, facilitates communication, and assists in finding mutually acceptable solutions. Mediation is often used in real estate disputes, such as those involving property boundaries, landlord-tenant issues, and contract disputes, as a way to resolve conflicts without resorting to formal litigation. 3. Nominal damages. Nominal damages are a symbolic or token amount of money awarded by a court to a plaintiff in a lawsuit to acknowledge that a legal right has been violated, even though no actual financial loss or harm has been suffered. Nominal damages are usually a small sum, such as $1, and are typically awarded in cases where there has been a technical breach of a legal duty or a violation of a legal right, but no significant damages or losses have been incurred. In real estate cases, nominal damages may be awarded in situations where there has been a minor breach of contract, trespass, or other legal violations that do not result in substantial financial harm. 4. Quiet title. Quiet title is a legal action or lawsuit that seeks to establish clear and undisputed ownership of a property by resolving any competing claims or disputes regarding the property's title. Quiet title actions are typically used to clarify or confirm ownership of real estate when there are conflicting or clouded titles, unresolved liens, or other issues that create uncertainty about the property's ownership. Quiet title actions aim to quiet or eliminate any claims or challenges to a property's title, and establish a clear and marketable title that can be freely transferred or sold. 5. Reformation. Reformation is a legal remedy that allows a court to modify or correct a contract or legal instrument that contains an error, omission, or mistake, in order to conform it to the original intent or understanding of the parties. Reformation is typically sought when a written contract or document does not accurately reflect the parties' intentions due to a mistake, fraud, duress, or other grounds. In the context of real estate, reformation may be used to correct errors in a deed, contract, or other legal documents related to the purchase, sale, or lease of property. 6. Regulatory law. Regulatory law refers to the body of laws, rules, and regulations that govern the conduct and activities of individuals, businesses, and organizations in a particular industry or sector. In the context of real estate, regulatory law encompasses the laws and regulations that govern the licensing and operation of real estate professionals, such as real estate agents, brokers, appraisers, and property managers, as well as the rules and regulations related to property development, construction, land use, zoning, and other aspects of the real estate industry. Regulatory law is aimed at protecting the interest of consumers, promoting fair competition, and ensuring compliance with industry standards and practices. 1. Rescission. Rescission is a legal remedy that allows a party to a contract to cancel or terminate the contract due to a material breach, fraud, misrepresentation, mistake, duress, undue influence, or other grounds recognized by law. In the context of real estate, rescission may be used in cases where a party has been induced to enter into a contract related to real property based on false or misleading information, or where there has been a significant breach of contract by the other party. Rescission typically restores the parties to their pre-contractual positions and requires the return of any consideration or benefits received under the contract. 2. Specific performance. Specific performance is a legal remedy that requires a party to perform their obligations under a contract as originally agreed upon, rather than seeking damages for a breach of contract. In the context of real estate, specific performance may be sought when a party to a contract for the sale or purchase of real property fails to perform their contractual obligations, such as failing to transfer title or failing to pay the purchase price. Specific performance is considered an extraordinary remedy and is typically granted when monetary damages are inadequate to compensate the injured party, and when the subject matter of the contract is unique or of special value, such as in cases involving unique properties or rare parcels of land. 3. Stare decisis. Stare decisis is a Latin term that means to stand by things decided. It is a legal doctrine that refers to the principle of adhering to precedents or previously decided cases when deciding similar legal issues in order to promote consistency and stability in the interpretation and application of the law. In the context of real estate, stare decisis may be invoked when interpreting statutes, regulations, or case law related to real property rights, land use, zoning, and other legal matters. Stare decisis promotes predictability and reliability in the legal system, as courts are generally expected to follow established precedents unless there are compelling reasons to depart from them. 4. Statutory law. Statutory law refers to the body of laws that are enacted by a legislative body, such as a federal, state, or local government, and are formally codified and published as statutes or ordinances. In the context of real estate, statutory law encompasses the laws and regulations that govern various aspects of property rights, property ownership, property transactions, land use, zoning, building codes, and other legal matters related to real property. Statutory law is created through the legislative process and is binding on all parties within the jurisdiction of the legislative body that enacted the law. 5. Venue. Venue refers to the geographic location or district where a legal case or lawsuit is filed and heard. It determines which court or jurisdiction has the authority to hear and decide a particular case. In the context of real estate, venue may be significant in cases involving property disputes, contract disputes, or other legal matters related to real property, as the appropriate venue may depend on factors such as the location of the property, the residence of the parties, or the type of legal issue involved. Proper venue is important for ensuring that legal cases are heard in the appropriate court or jurisdiction, and that the parties have access to a fair and impartial judicial process. Unit 2. Law of Agency. 1. Agency. Agency refers to the legal relationship between a principal and an agent, where the agent acts on behalf of the principal and has the authority to represent the principal in dealings with third parties. In the context of real estate, agency commonly arises in the relationship between a real estate agent, the agent, and their client, the principal, typically in the form of a listing agreement or a buyer's agency agreement. The agent owes fiduciary duties to the principal, including loyalty, obedience, disclosure, confidentiality, and accountability, and is obligated to act in the best interest of the principal while carrying out the duties and responsibilities of the agency relationship. 2. Agency coupled with an interest. Agency coupled with an interest is a legal doctrine that allows an agent to have a personal stake or interest in the subject matter of the agency relationship, which gives the agent a financial or other interest in the outcome of the transaction. This interest may not be easily terminated or revoked by the principal, and the agent may have the authority to act on their own behalf as well as on behalf of the principal. In the context of real estate, agency coupled with an interest may arise in situations where the agent has a financial interest in the property being sold, such as when the agent is also a co-owner or investor in the property. 3. Agent. An agent is a person who is authorized to act on behalf of another person or entity, the principal, and represents the interests of the principal in dealings with third parties. In the context of real estate, an agent may refer to a licensed real estate agent or a broker who is engaged by a client, the principal, to represent their interests in buying, selling, or leasing real property. The agent owes fiduciary duties to the principal and is bound by the agency relationship, which includes acting in the best interests of the principal, providing competent and diligent representation, and disclosing material information. 4. Attorney-in-fact. An attorney-in-fact is a person who is granted authority by a power of attorney to act on behalf of another person, the principal, in legal and financial matters. In the context of real estate, an attorney-in-fact may be appointed by a property owner to handle various aspects of real estate transactions, such as signing documents, negotiating contracts, or managing property on behalf of the principal. The attorney-in-fact acts under the authority and direction of the principal and has a fiduciary duty to act in the best interests of the principal. 5. Customary authority. Customary authority refers to the implied authority that an agent may have to act in certain ways or make certain decisions based on customary practices or industry standards. In the context of real estate, customary authority may allow a real estate agent to take certain actions or make certain decisions on behalf of their client, the principal, without obtaining explicit authorization, as long as those actions or decisions are consistent with customary practices in the real estate industry. 6. Dual agency. Dual agency is a real estate agency relationship in which an agent represents both the buyer and the seller in the same transaction. In other words, the same real estate agent or broker represents both parties to a transaction, which may create a potential conflict of interest. Dual agency is subject to specific laws and regulations in many jurisdictions, and it requires the agent to fully disclose the dual agency relationship to both parties and obtain their informed consent. Dual agency may have limitations on the extent to which the agent can represent the best interests of both parties and may require careful management to avoid conflicts of interest. 1. Equal dignities rule. The equal dignities rule is a legal doctrine that requires certain types of agency relationships, specifically those involving the authority to execute contracts that are required to be in writing, to be evidenced in writing in order to be valid. In the context of real estate, the equal dignities rule may come into play when an agent is given the authority to sign contracts on behalf of their principal, such as a listing agreement or a purchase contract, which are typically required to be in writing under the statute of frauds. The equal dignities rule helps ensure that the agent's authority to bind the principal to a contract is properly documented in writing. 2. Estoppel. Estoppel is a legal doctrine that prevents a party from asserting a claim or defense that is inconsistent with their previous words, actions, or conduct, when such inconsistency would unfairly harm another party. In the context of real estate, estoppel may arise when an agent or a principal makes representations or promises that another party relies upon, and the party who made the representations or promises is then prevented from denying or changing those representations or promises. Estoppel may be used to prevent an agent or principal from asserting a different position or denying the authority or actions of the agent in a real estate transaction. 3. Express agency. Express agency refers to an agency relationship that is created by an explicit agreement, either written or verbal, between the principal and the agent. In other words, express agency occurs when the principal expressly grants authority to the agent to act on their behalf and represent their interests in specific transactions or matters. In the context of real estate, express agency is typically established through a written listing agreement or a buyer's agency agreement, where the agent is given specific authority to represent the principal in buying, selling, or leasing real property. 4. Express authority. Express authority is the specific and explicit authorization given by a principal to an agent to act on their behalf and represent their interests in a transaction or matter. Express authority may be given in writing or verbally, and it outlines the scope and limitations of the agent's authority. In the context of real estate, express authority may be granted through a written listing agreement or a buyer's agency agreement, and it may include the power to sign contracts, negotiate terms, or make decisions on behalf of the principal in real estate transactions. 5. Fiduciary duty. Fiduciary duty refers to the highest standard of care and loyalty that an agent owes to their principal. In the context of real estate, a fiduciary duty is a legal obligation that requires an agent to act in the best interest of their client, the principal, and prioritize their interests above their own or any other party's interests. Fiduciary duties in real estate typically include loyalty, obedience, disclosure, confidentiality, and accountability, and they require the agent to act with the utmost care, diligence, and honesty in representing the principal's interests. 6. General agent. A general agent is an agent who has broad authority to represent the principal in a wide range of matters or transactions, typically within a specific scope of business or industry. In the context of real estate, a general agent may be a real estate broker who is authorized to represent a principal in various real estate transactions, such as buying, selling, leasing, or managing properties, and who has the authority to bind the principal to contracts and other legal obligations within the scope of their agency relationship. 7. Implied agency. Implied agency refers to an agency relationship that is created by the actions, conduct, or circumstances of the parties involved, even without an explicit agreement. In other words, implied agency occurs when the principal and the agent do not have a formal written or verbal agreement, but their actions and conduct imply that the agent has authority to act. 1. Ostensible agency. Ostensible agency, also known as apparent agency, is a legal concept that occurs when a principal creates the appearance of an agency relationship with a third party, even though there may not be a formal agency agreement. In other words, ostensible agency arises when a principal leads others to believe that an individual has authority to act as their agent, and the third party relies on that belief to their detriment. In the context of real estate, ostensible agency may occur when a principal represents or holds out an individual, such as a real estate agent, as their agent, and a third party relies on that representation and enters into a transaction with the agent based on that belief. 2. Power of attorney. A power of attorney is a legal document that grants authority to an individual, known as the attorney in fact or agent, to act on behalf of another person, known as the principal, in making legal, financial, or other decisions. In the context of real estate, a power of attorney may be used to authorize someone to act on behalf of the principal in real estate transactions, such as buying, selling, or managing properties. A power of attorney can be limited or general, and it can be created for a specific transaction or for a broader scope of authority. 3. Principal. In the context of real estate, a principal refers to a person or entity who grants authority to another person or entity, known as the agent, to act on their behalf and represent their interests in a transaction or matter. The principal is the party who retains control over the agent's actions and bears the legal and financial consequences of the agent's actions within the scope of the agency relationship. The principal may be a property owner, a landlord, a buyer, a seller, or any other party who authorizes an agent to act on their behalf in a real estate transaction. 4. Ratification. Ratification is a legal concept that occurs when a principal approves or accepts the actions of an agent after the agent has acted without prior authority or exceeded their authority. In other words, ratification is the retroactive validation of an agent's unauthorized actions by the principal. In the context of real estate, ratification may occur when an agent enters into a contract on behalf of the principal without prior authorization, and the principal later approves or accepts the contract, thereby ratifying the agent's actions and becoming legally bound by the contract. 5. Respondent superior. Respondent superior is a legal doctrine that holds an employer or principal liable for the actions or omissions of their employees or agents that occur within the scope of their employment or agency relationship. In the context of real estate, respondent superior may apply when an agent, such as a real estate agent or a broker, commits a negligent act or omission while acting within the scope of their agency relationship, and the principal, such as the real estate agency or brokerage, may be held liable for the agent's actions or omissions. 6. Secret agent. A secret agent is an agent who acts on behalf of a principal without disclosing their agency relationship to third parties. In other words, a secret agent operates under a cloak of anonymity and does not reveal their status as an agent for the principal. In the context of real estate, a secret agent may be someone who represents a principal in a real estate transaction without disclosing their agency relationship to the other party, potentially creating legal implications and responsibilities for both the agent and the principal. 7. Special agent. A special agent is an agent who is authorized to represent the principal in a specific transaction or matter, and whose authority is limited to that specific transaction or matter. In other words, a special agent's authority is narrow and confined to a particular purpose or task, as opposed to a general agent who has broader authority. 1. Tort. In the context of real estate, a tort refers to a wrongful act or omission committed by one party that causes harm or damage to another party's property, rights, or interests. Torts in real estate can include actions such as negligence, fraud, misrepresentation, trespass, nuisance, and other wrongful acts or omissions that result in harm or financial loss to another party. Torts in real estate can give rise to legal liability, and the injured party may seek damages or other legal remedies to compensate for the harm caused. 2. Vicarious liability. Vicarious liability is a legal concept that holds one party liable for the actions or omissions of another party, even if the first party did not personally commit the wrongful act or omission. In the context of real estate, vicarious liability may apply when an agent, such as a real estate agent or a broker, commits a tortious act or omission while acting within the scope of their agency relationship, and the principal, such as the real estate agency or brokerage, may be held liable for the agent's actions or omissions. Vicarious liability is based on the legal principle that the principal or employer should bear the responsibility for the actions of their agent or employee, and it can have significant implications for real estate transactions and legal disputes involving agents and principals. Unit 5 Law of Contracts 1. Accord and Satisfaction. Accord and satisfaction is a legal concept in real estate that refers to an agreement between parties to settle a dispute or claim by offering and accepting an alternative performance or consideration, other than what was originally agreed upon in the contract. It involves the parties coming to a new agreement, accord, and the performance of that new agreement, satisfaction, in order to discharge the original contractual obligation. Accord and satisfaction can be used as a means of resolving contractual disputes or claims without resorting to litigation or other legal remedies. 2. Anticipatory breach. Anticipatory breach, also known as anticipatory repudiation, occurs in real estate when one party to a contract expresses, either through words or actions, an intention not to perform their contractual obligations before the time for performance has arrived. This can include a clear statement of refusal to perform or conduct that makes it impossible for the party to perform their obligations. Anticipatory breach allows the non-breaching party to consider the contract as terminated and pursue legal remedies for breach of contract without waiting for the actual performance date. 3. Assignment of contract. Assignment of contract is a legal process in real estate whereby one party transfers their rights and obligations under a contract to another party. The party transferring their rights and obligations is known as the assignor, and the party receiving the rights and obligations is known as the assignee. Assignments of contract are common in real estate transactions, such as wholesaling, where an investor may assign their rights under a purchase contract to another investor or buyer for a fee. 4. Bilateral contract. A bilateral contract is a type of contract in real estate where both parties make promises to each other and are obligated to perform their respective promises. In other words, it is a mutual exchange of promises where each party is bound to perform their part of the contract upon the other party's performance. Bilateral contracts are commonly used in real estate transactions, such as purchase agreements, where both parties make promises to buy and sell a property. 5. Breach of contract. Breach of contract occurs in real estate when one party fails to fulfill their obligations or fails to perform as promised under a valid and enforceable contract. A breach of contract can occur in various forms, including non-performance, partial performance, or delayed performance, and can result in legal consequences, such as damages, specific performance, or termination of the contract. Breach of contract is a common legal issue in real estate transactions and may require resolution through negotiation, mediation, arbitration, or litigation. 6. Commercial frustration. Commercial frustration, also known as frustration of purpose, is a legal concept in real estate that occurs when unforeseen events or circumstances arise after the formation of a contract that render the performance of the contract impossible, impracticable, or fundamentally different from what the parties originally contemplated. Commercial frustration may discharge the parties from their contractual obligations and excuse performance if it is proven that the unforeseen events or circumstances were beyond the control of the parties and not contemplated at the time of contract formation. 7. Contract of adhesion. A contract of adhesion is a type of contract in real estate that is drafted by one party, typically a party with greater bargaining power, and offered to the other party on a take-it-or-leave-it basis, without much opportunity for negotiation or modification. The party with lesser bargaining power is typically required to accept the terms of the contract as presented or forego the opportunity to enter into the transaction. Contract of adhesion are often characterized by standardized, pre-printed terms and conditions that are not subject to negotiation. In some cases, courts may scrutinize contracts of adhesion for unfair or unconscionable terms and may provide protections to the party with lesser bargaining power. 1. Divisible contract. A divisible contract is a type of contract in real estate where the parties' obligations are divided into separate parts or performances, and the failure to perform one part does not necessarily affect the other parts. In other words, a divisible contract can be partially performed or partially breached, and the non-breaching party may still be entitled to the performance of the remaining parts of the contract. Divisible contracts are commonly used in real estate transactions, such as construction contracts or installment contracts, where performance or payment is divided into stages or installments. 2. Duress. Duress is a legal concept in real estate that occurs when one party is forced or coerced into entering into a contract against their will, typically through threats, intimidation, violence, or other wrongful conduct. Duress can render a contract voidable, meaning that the party who was coerced may have the option to rescind or avoid the contract. In order for duress to be a valid defense to a contract, it must be proven that the threats or coercion were unlawful, and that they overcame the free will of the party who was coerced. 3. Emancipated minor. An emancipated minor is a minor, typically under the age of 18, who has been legally recognized as having the capacity to enter into contracts and manage their own affairs, as if they were an adult. Emancipation can occur through various means, such as through marriage, court order, or statutory provision, and it typically releases the minor from the legal disabilities and limitations that would otherwise apply to minors. Emancipated minors may be able to enter into binding contracts, including real estate contracts, without the need for parental or guardian consent. 4. Estoppel. Estoppel is a legal doctrine in real estate that prevents a party from denying or contradicting a representation or statement of fact that they previously made, when another party relied on that representation or statement to their detriment. In other words, estoppel prevents a party from taking a position that is inconsistent with their prior representations or actions. Estoppel can arise in various contexts in real estate, such as when a party makes a representation or promise regarding a property's condition or title, and another party relies on that representation or promise to their detriment. 5. Executed contract. An executed contract is a type of contract in real estate where all parties have performed their obligations and fulfilled the terms of the contract. In other words, an executed contract is a contract that has been fully performed and is no longer enforceable because all parties have fulfilled their promises. Executed contracts are commonly used in real estate transactions, such as when a property has been sold and all parties have completed their obligations, including the transfer of title, payment of purchase price, and delivery of possession. 6. Executory contract. An executory contract is a type of contract in real estate where one or more parties have not yet performed their obligations or fulfilled the terms of the contract. In other words, an executory contract is a contract that is still in the process of being performed, and the parties have yet to fully perform their promises. Executory contracts are commonly used in real estate transactions, such as purchase agreements or lease agreements, where one or more parties have obligations that are still pending and have not yet been fulfilled. 7. Express contract. An express contract is a type of contract in real estate that is formed when the parties clearly and explicitly state their intentions and promises, either orally or in writing. An express contract is created through the parties' express agreement and may be in the form of a written contract, an oral agreement, or a combination of both. Express contracts are commonly used in real estate transactions, such as purchase agreements, lease agreements, or construction contracts, where the parties' intentions and promises are clearly. 1. Illusory contract. An illusory contract is a type of contract in real estate that appears to be a valid contract on its face, but lacks consideration or mutuality of obligation, making it unenforceable. In other words, an illusory contract is a contract where one party's promise is conditional or uncertain, and does not create a legally binding obligation. Illusory contracts are generally not enforceable because they lack the essential elements of a valid contract, such as consideration, which is the mutual exchange of something of value between the parties. 2. Implied contract. An implied contract is a type of contract in real estate that is formed based on the parties' conduct and actions, rather than through explicit written or oral agreements. An implied contract is created when the parties' conduct implies their intention to be bound by a contract, even though they may not have explicitly stated their intentions in writing or orally. Implied contracts are based on the parties' behavior and the reasonable expectations of the parties, and can be enforceable just like express contracts. 3. Judgment. In real estate, a judgment refers to a legal decision or order rendered by a court of law, typically in a civil lawsuit, that determines the rights and liabilities of the parties involved. Judgments can arise in various real estate contexts, such as disputes over property ownership, contract breaches, or other legal issues. A judgment may require a party to pay damages, perform a specific action, or refrain from certain actions, and can be legally enforceable. 4. Laches. Laches is a legal doctrine in real estate that refers to the unreasonable delay or neglect by a party in asserting their legal rights, which may result in the loss of those rights. In other words, laches is a defense that can be raised when a party fails to timely assert their rights, and as a result, the other party suffers prejudice or harm. In real estate, laches can be invoked in various situations, such as disputes over property boundaries, easements, or other property rights. 5. Liquidated damages. Liquidated damages are a type of damages in real estate that are agreed upon by the parties in a contract in advance, and are intended to compensate one party for the other party's breach of contract. Liquidated damages are typically specified as a fixed amount or a formula in the contract, and are meant to estimate the actual damages that may be suffered by the non-breaching party in case of a breach. Liquidated damages are enforceable if they are reasonable and not intended to penalize the breaching party. 6. Menace. Menace is a legal concept in real estate that refers to threats, coercion, or intimidation by one party towards another party, with the intent to force the other party into entering into a contract against their will. Menace can render a contract voidable, meaning that the party who was coerced may have the option to rescind or avoid the contract. Menace can include actions such as threats of violence, blackmail, or other wrongful conduct, and can be a valid defense to a contract if proven. 7. Novation. Novation is a legal concept in real estate that refers to the substitution of a new contract or a new party in place of an existing contract or party, with the mutual agreement of all parties involved. Novation typically requires the consent of all parties, and results in the discharge of the original contract and the creation of a new contract with new terms or parties. Novation is commonly used in real estate transactions, such as when there is a change in ownership or when parties wish to modify the terms of an existing contract. 1. Option. In real estate, an option refers to a contractual agreement between parties where one party grants another party the right, but not the obligation, to buy or sell a property within a specified period of time and at a predetermined price. The party who holds the option is known as the option, while the party who grants the option is known as the optioner. An option gives the option the right to exercise the option and enter into a formal contract, but does not impose an obligation to do so. Options are commonly used in real estate transactions as a way to secure the right to purchase or sell a property at a future date. 2. Parole evidence rule. The parole evidence rule is a legal doctrine in real estate that limits the use of oral or written evidence that contradicts or varies the terms of a written contract that has been fully integrated, meaning that it represents the complete and final understanding of the parties. In other words, the parole evidence rule prevents parties from introducing additional evidence, such as oral or written representations made prior to or contemporaneous with the written contract, to alter or add to the terms of the written contract. The parole evidence rule is designed to promote the finality and enforceability of written contracts in real estate transactions. 3. Quasi-contract. A quasi-contract, also known as an implied-in-law contract or a constructive contract, is a legal concept in real estate that is not based on an actual agreement between parties, but is imposed by law to prevent unjust enrichment. In other words, a quasi-contract is a fictional contract created by a court to ensure that one party is not unfairly enriched at the expense of another party. Quasi-contracts are typically used in situations where there is no express contract between the parties, but one party has received a benefit from another party that would be unfair to retain without compensating the other party. 4. Right of first refusal. The right of first refusal is a contractual right in real estate that gives a party the option to enter into a contract or purchase agreement for a property before it can be sold or leased to another party. In other words, the right of first refusal gives a party the first opportunity to purchase or lease a property if the owner decides to sell or lease it to a third party. The right of first refusal is typically negotiated and included in contracts or lease agreements, and can be a valuable right for a party to protect their interests in a real estate transaction. 5. Seals. Seals are formal symbols or marks used in real estate to indicate that a contract or legal document is intended to be legally binding and enforceable. Seals were traditionally used in contracts to signify that the parties intended to be bound by the contract, and were typically affixed to the document with a wax seal or other formal mark. However, in modern real estate transactions, seals are less commonly used and may not be required for a contract to be valid and enforceable. 6. Statute of frauds. The statute of frauds is a legal doctrine in real estate that requires certain types of contracts to be in writing and signed by the parties in order to be enforceable. The purpose of the statute of frauds is to prevent fraud and ensure that contracts involving important or valuable transactions are in writing and can be proven in court. The types of contracts that are typically subject to the statute of frauds in real estate include contracts for the sale of real property, contracts for the lease of real property for a period of 1 year or more, and contracts to transfer an interest in real property. 7. Third-party beneficiary. A third-party beneficiary is a party in a contract who is not a party to the contract, but who may have enforceable rights or benefits under the contract. 1. Time is of the essence. In real estate, time is of the essence is a contractual clause that emphasizes the importance of strict adherence to deadlines and timelines specified in a contract. This clause indicates that time is a critical factor in the performance of the contract, and any delays or failures to meet deadlines may result in consequences such as termination, forfeiture of rights, or other contractual remedies. Time is of the essence is often used in real estate contracts for actions such as closing dates, financing contingencies, or other time-sensitive obligations, and it emphasizes the need for timely performance by the parties involved. 2. Undue influence. Undue influence is a legal concept in real estate that refers to a situation where one party uses improper or unfair persuasion or influence to induce another party to enter into a contract or transaction. Undue influence occurs when one party takes advantage of a position of power, trust, or authority over another party to obtain an unfair advantage in a contract or transaction. In real estate, undue influence can occur in various situations, such as when a party is vulnerable due to age, mental capacity, or other circumstances, and is coerced or manipulated into entering into a contract against their best interests. 3. Uniform Electronic Transactions Act, UETA. The Uniform Electronic Transactions Act is a model law in the United States that provides a legal framework for the use of electronic signatures, records, and contracts in real estate transactions. The UETA establishes the legal validity and enforceability of electronic signatures and records, and it ensures that electronic transactions have the same legal effect as traditional paper-based transactions. The UETA provides guidelines for the use of electronic signatures and records in various types of transactions, including real estate contracts, leases, and other documents, and it helps facilitate the use of electronic technologies in modern real estate transactions. 4. Unilateral contract. A unilateral contract is a type of contract in real estate where one party makes a promise to another party in exchange for the performance of a specific act or condition, and the contract is formed only when the act or condition is completed. In other words, a unilateral contract is a one-sided contract where one party makes a promise that is contingent upon the other party's performance. The party making the promise is known as the offeror, and the party performing the act or condition is known as the offeree. Unilateral contracts are commonly used in real estate for situations such as option contracts, where the offeree has the option to accept the offer by performing the specified act or condition. 5. Valid contract. A valid contract is a legally binding and enforceable agreement between parties in real estate that meets all the essential elements of a contract. In order for a contract to be valid, it must typically include the following elements: offer and acceptance, consideration, that is, something of value exchanged between the parties, mutual consent, legal capacity of the parties to enter into a contract, and a lawful purpose. A valid contract creates legally binding rights and obligations for the parties involved, and it can be enforced by a court of law if one of the parties fails to fulfill their obligations under the contract. 6. Voidable contract. A voidable contract is a contract in real estate that is initially valid and enforceable, but can be voided or cancelled by one of the parties under certain circumstances. Voidable contracts are contracts that are entered into based on a mistake, fraud, duress, undue influence, or other grounds that give one of the parties the right to rescind or cancel the contract. Unlike void contracts, which are considered legally invalid from the beginning and have no legal effect, voidable contracts are initially valid but can be voided by one of the parties if the required grounds exist. 1. Void contract. A void contract in real estate is a contract that is considered legally invalid and unenforceable from the beginning. A void contract lacks the essential elements of a valid contract, such as mutual consent, consideration, legal capacity of the parties, or a lawful purpose. As a result, a void contract has no legal effect and cannot be enforced by a court of law. In other words, the parties to a void contract have no legal obligations or rights under the contract, and any actions taken based on a void contract are considered void ab initio, meaning they are treated as if they never occurred. 2. Waiver. Waiver in real estate refers to the voluntary relinquishment or abandonment of a legal right or claim by a party to a contract. A waiver occurs when a party intentionally and explicitly gives up their right to enforce a provision or requirement of a contract, either through a written or verbal statement, or through their conduct or behavior. Waiver can be express, where a party explicitly states that they are waiving a right, or implied, where a party's actions or inactions indicate that they are waiving a right. Waiver in real estate contracts can have legal consequences, as it may affect the rights and obligations of the parties involved and can impact the enforceability of the contract. It is important for parties to carefully consider the implications of waiving their rights in a real estate contract and seek legal advice if needed. Unit 6 Real Estate Contracts. 1. Advance costs. In real estate, advance costs refer to expenses incurred by a party in a real estate transaction that are paid upfront before the closing or settlement takes place. These costs may include expenses such as appraisal fees, inspection fees, title search fees, and other costs associated with the purchase or sale of a property. Advance costs are typically the responsibility of the party who initiates the transaction, such as the buyer or seller, as outlined in the purchase contract or other relevant agreements. 2. Advance fee addendum. An advance fee addendum in real estate is a contractual agreement that outlines the terms and conditions for the payment of advance fees by a party in a real estate transaction. Advance fees are fees paid by a party, often the buyer or seller, to a real estate professional, such as a real estate agent or a broker, before the services are rendered. The advance fee addendum typically specifies the amount of the fee, the services to be provided, and the conditions under which the fee may be refundable or non-refundable. 3. Burden of proof. In real estate, the burden of proof refers to the responsibility of a party to provide evidence or prove the truth of their claims or assertions in a legal or contractual dispute. The burden of proof typically lies with the party who asserts a claim or seeks to enforce a right or obligation. In a real estate transaction, for example, if a party alleges that a breach of contract has occurred or that certain representations or warranties have been made, the burden of proof would be on that party to provide evidence to support their claim. 4. Buyer listing agreements. Buyer listing agreements in real estate are contractual agreements between a buyer and a real estate agent or broker that outline the terms and conditions of the agent's services in representing the buyer in their property search and purchase. Buyer listing agreements typically cover details such as the duration of the agreement, the scope of the agent's services, the buyer's obligations, and the compensation arrangements. These agreements are legally binding and specify the rights and responsibilities of both the buyer and the real estate professional during the course of the buyer's property search and purchase process. 5. Cooperating broker fee agreements. Cooperating broker fee agreements in real estate refer to contractual agreements between real estate brokers or agents representing the buyer and seller, respectively, in a transaction. These agreements outline the terms and conditions for the payment of a cooperating broker fee, also known as a buyer's agent commission or a selling agent commission, to the broker or agent who brings the buyer to the transaction. The cooperating broker fee is typically paid by the seller as part of the overall commission structure, and the agreement specifies the amount or percentage of the fee, the conditions under which it is earned, and the responsibilities of the cooperating broker or agent. 6. Due diligence. In real estate, due diligence refers to the comprehensive investigation and analysis of a property or a real estate transaction by a party before entering into a purchase, sale, or lease agreement. Due diligence typically involves conducting thorough inspections, reviewing relevant documents and records, verifying information, and assessing the risks and potential liabilities associated with the property or the transaction. Due diligence is an important process that allows parties to identify and mitigate risks, make informed decisions, and ensure that the transaction is in their best interest. 7. Exclusive agency listing. An exclusive agency listing in real estate is a contractual agreement between a property owner, seller, and a real estate agent or a broker, granting the agent or broker the exclusive right to market and sell the property during the term of the listing agreement. In an exclusive agency listing, the seller retains the right to sell the property themselves without paying a commission to the listing agent, unless the agent or broker procures a buyer for the property. 1. Exclusive authorization and right to sell listing. In real estate, an exclusive authorization and right to sell listing is a contractual agreement between a property owner, seller, and a real estate agent or a broker, granting the agent or broker the exclusive right to market, advertise, and sell the property for a specified period of time. With an exclusive authorization and right to sell listing, the seller agrees to work exclusively with the listing agent or broker and pays a commission to the agent or broker regardless of who procures a buyer for the property, including if the seller finds a buyer on their own. This type of listing provides the highest level of representation and commitment from the listing agent or broker. 2. Good faith. Good faith in real estate refers to the honest, sincere, and diligent effort made by parties in a transaction to act fairly, honestly, and in a trustworthy manner towards each other. Good faith is a fundamental principle of real estate transactions and requires parties to deal with each other honestly, disclose all material facts, and fulfill their contractual obligations to the best of their ability. Good faith is essential in building trust and maintaining the integrity of real estate transactions. 3. Hold harmless clauses. Hold harmless clauses, also known as indemnity clauses, in real estate are contractual provisions that allocate responsibility for certain risks, damages, or liabilities between parties involved in a transaction. Hold harmless clauses are intended to protect one party from financial loss or legal claims arising from certain actions or events related to the transaction. These clauses may vary in scope and specificity, and their enforceability may depend on local laws and regulations. 4. Interim occupancy agreement. Interim occupancy agreement in real estate is a contractual agreement between a buyer and seller that allows the buyer to occupy and use the property before the closing or settlement takes place. Interim occupancy agreements typically outline the terms and conditions for the buyer's temporary use of the property, including responsibilities for maintenance, utilities, insurance, and other related matters. These agreements are used when the buyer takes possession of the property before the transfer of ownership is completed, and they may include provisions for rent or compensation paid by the buyer to the seller for the use of the property during the interim period. 5. Loan broker listing. A loan broker listing in real estate refers to a contractual agreement between a property owner, seller, and a real estate agent or broker who specializes in arranging loans or financing for buyers. A loan broker listing typically authorizes the agent or broker to market and advertise the property as a potential investment property or an opportunity for financing, and may specify the terms and conditions under which the agent or broker is entitled to a commission or fee. 6. No deal, no commission, no deal. No commission in real estate is a contractual provision that stipulates that a real estate agent or broker is entitled to a commission only if they successfully complete a sale or lease transaction. If no transaction occurs, the agent or broker is not entitled to any commission or fee for their services. This provision is commonly used in real estate listing agreements or buyer representation agreements to clarify the circumstances under which the agent or broker is entitled to compensation for their efforts in facilitating a successful transaction. 7. Open listings. Open listings in real estate refer to non-exclusive listing agreements between a property owner, seller, and multiple real estate agents or brokers, where the seller retains the right to enter into similar agreements with other agents or brokers or to sell the property themselves without paying a commission. With open listings, the seller is not obligated to work exclusively with any particular agent or broker, and commissions are typically only paid to the agent or broker who procures a buyer and successfully completes a transaction. Open listings provide flexibility for the seller to work with multiple agents or brokers simultaneously. 1. Privity of contract. Privity of contract in real estate refers to the legal relationship between parties who have entered into a contractual agreement. It signifies that the parties to the contract are bound by the terms and conditions of the contract, and have the right to enforce those terms against each other. Privity of contract typically exists between the original parties to the contract, such as the buyer and seller, landlord and tenant, or agent and principal. It may also have implications for third parties who are beneficiaries or signees of the contract. 2. Procuring cause. Procuring cause in real estate refers to the actions or efforts of a real estate agent or broker that are deemed to be the direct and effective cause of a successful sale or lease transaction. The concept of procuring cause is important in determining which agent or broker is entitled to a commission or fee for their services in a transaction where multiple agents or brokers may have been involved. Factors such as the agent's initiation of contact with the buyer or tenant, negotiation of terms, submission of an offer, and overall contribution to the transaction may be considered in determining the procuring cause. 3. Safety clause. A safety clause in real estate, also known as a safety net or protection clause, is a contractual provision that provides protection to a real estate agent or broker in case the seller or landlord enters into a transaction with a prospective buyer or tenant after the listing or representation agreement has expired. The safety clause typically allows the agent or broker to be entitled to a commission or fee if the transaction with the prospective buyer or tenant occurs within a certain period of time after the expiration of the listing or representation agreement. The purpose of a safety clause is to protect the agent or broker's efforts in bringing the buyer or tenant to the seller or landlord during the term of the agreement, even if the transaction is concluded after the agreement has ended. The specific terms and conditions of a safety clause may vary depending on the jurisdiction and the language of the agreement.